Perfect. So then thank you very much, Logan, for this nice introduction and for the possibility to speak today to you. And a short agenda, what do we want to talk about today? And first of all, a short personal introduction is not necessary anymore. Thank you very much, Logan. So we can come to the main point. What is our use case today? I will explain it a little bit later in detail. And the main or the most important questions regarding this topic, home office abroad, is in which country do you have to pay your taxes and in which country do you have to pay your social security contributions. And in the end, I have some very short further legal hints. And if you have afterwards some question, feel free to ask me. So I will do not make the personal introduction again, but if you want to connect with me, you can use this QR code and go on my website, and there you will find all my social platforms like Facebook, LinkedIn, Instagram, YouTube, and so on. So what is our use case for today? During this short webinar, I want to, as Logan already mentioned, to give you a short overview of the legal consequences if you work abroad for some weeks, months, or for an extended period of time. And since Corona at the latest, luckily, more and more people are working from home, and many people choosing to escape the city in more pleasant locations like Spain. And that's why I choose this use case to keep it very simple and short, to give you a really rough overview that you know in the future, okay, this is what I have to think about if I intend to work cross-border. So our typical use case for today is you live and work in Germany for a German company and choose to escape the city, maybe Berlin, and work abroad, for example, in Spain. And starting from this case, you should ask the following question: in which country do I have to pay my taxes? And for that, you have to clarify, first of all, in which country do I have my tax residency? That means you have to clarify which country, in that case, Germany or Spain, has the right of taxation. And the problem is, if you are working permanently from another country, for example, in another country, but for a company which is based in Germany, both countries, Spain and Germany, could have the right of taxation. And your task as a taxable person is obviously to clarify which country has the right of taxation. Is it Germany or Spain? And starting from our use case that you were working in Germany for a German film, you would have to ask yourself, how long will you be considered as a tax resident in Germany according to the German tax law? And what does it mean, tax residency? Tax residency means in which country do you have your place of residence or your habitual abode? And now I want to differentiate between employees and freelancers, because there are small differences between both groups of persons. Starting with the employees. If the employee has no place of residence in Germany and is not staying in Germany for more than 6 months, oh, sorry, I forgot the first step. If the employee does not stay abroad for more than 183 days, which are 6 months within a fiscal year, then usually Germany has the right of taxation. And according to the German tax law, this is the so-called unlimited tax liability. If the employee has no place of residence in Germany anymore and is not staying in Germany for more than 6 months, Germany has still the right of taxation, but only regarding the income from your German employer. And what is the reason for that? It is because your work will be exploited locally in Germany, although you work from home in another country, for example, Spain. And now the good news for employees, usually your employer will handle that situation, because according to the German law, the employer is obligated to pay your wage taxes in your name to the finance authorities in Germany. And there is a procedure, but I do not know the word in English. In German, it's called Lohnsteuerabzugsverfahren. That is why if you are an employee and intend to work cross-border just for some months, it is not such a big problem, and usually you will get the help and support of your employer. Just for your information, just in case Germany has not the right of taxation anymore, and for example, Spain would have the right of taxation, then usually you need a certificate, a so-called certificate of exemption, which is in Germany Freistellungsbescheinigung, and you can get this from the German finance authorities. And this certificate confirms that you are not obligated to pay your wage tax in Germany, because Germany has not the right of taxation anymore. And as I said, usually your employer will support you in this matter, but I want that you know that this is a possibility to prove in which country do you have to pay your taxes, and also to prove your country that you are not obligated to pay your taxes on your income, for example, in Germany. And that's why it's important to know that a certificate like that is possible to get. And at the end, you should keep in mind, although your employer is responsible for paying your wage taxes in Germany, that in the end, you are the taxable person, you are the taxpayer. And that means you are always responsible to prove where do you actually live. So I recommend to archive all documents which can prove in which country do you actually work and live, for example, with the help of flight tickets or rental contract. This is really helpful in cases like that. This is it so far regarding employees. And regarding the second group, the freelancer, pretty much the same rules applies. So if the freelancer does not stay abroad for more than 183 days, again, it is 6 months within a fiscal year, then usually Germany has the right of taxation. As opposed to an employee, you have to file your tax return towards the German tax authorities by yourself, because obviously you do not have an employer who's paying your taxes automatically for you. And that is why I always recommend, if you work as a self-employed person, as a freelancer, to clarify right in the beginning, does Germany has the right of taxation, or maybe it is Spain? And for that, you can also contact the finance authorities, because if you are a freelancer, it's only your own responsibility to clarify this question. And that is why it is important as opposed to an employee. If the freelancer works abroad for more than 6 months and has no place of residence in Germany anymore, then you would be considered as a non-resident with a limited tax liability with its income from a German firm. So this is important to keep in mind. As long as you get an income from a German firm, basically you have to pay taxes on this income in Germany, because your work will be exploited in Germany. And regarding these two types of persons, employees and freelancers, I want to give you one important hint, because this example is really simple, and in detail, these tax rules from the German law perspective are quite complicated, really also for a lawyer. I just want that you keep in mind, the above mentioned hints are always dependent on the exact country in which you reside at the moment. In our case, for example, Spain. Because the question, in which country do you have to pay your taxes on your income, is always dependent on the so-called double taxation agreement. In German, this is called Doppelbesteuerungsabkommen. And what does it mean? This is an agreement between countries. For example, this is an agreement between Germany and Spain. And in this agreement, it is ruled which country have the right of taxation regarding your income as an employee or your income as a freelancer. And that is why I cannot, or you cannot say it is always like that. You always have to review in which country do you reside, and is there a double taxation agreement with the respective country. And usually Germany has, with the most of the countries in the world, a so-called double taxation agreement. So this shouldn't be a big problem. To sum up this first question, you always have to clarify in which country you will be considered as a tax resident, and this is written usually also in the double taxation agreement. And that is why it is always important to review the respective individual situation, and I will recommend usually with the help of a tax advisor in Germany. And if it's really complicated, you should hire a tax lawyer to avoid any disputes with the finance authorities, because the answer of this question, where is your tax residency, is unfortunately always depending on very small details regarding your current situation. This is it so far from the tax perspective. And now we will come to the, from my opinion, more important question. The more important question from my perspective for digital, or for the digital generation, is in which country do I have to pay my social security contributions? Because while tax law is only about whether you pay your taxes in the right country, the question of the applicable social security law concerns you personally as an individual. What does it mean? If you intend to work abroad or cross-border for more than some weeks, or even permanently cross-border, you should clarify as soon as possible which social security law is applicable to you. First of all, because the social security is obviously an important achievement for you as an employee, and also if you choose as a freelancer, because it gives you security in case of unemployment, illness, and later, and this is the most important thing, your pension. And that is why I would highly recommend to avoid to switch the social security systems too often in your life, because it is really complicated to foresee what will be the consequences regarding your pension claims in the respective country in which you paid your social security contributions. And that is why, from my perspective, I would really be aware of the fact in which country do I pay my pension and when will I get my pension claims. And due to the fact, from my perspective, that people of our generation will work permanently cross-border in the future because of all the growing digital work possibilities, you should really be aware of this fact and ensure that you get the social security services for which you pay, to be honest. And starting from this reason, or starting from this, the most important question is whether an employee or freelancer can continue to be insured under the German social security system to get health insurance, nursing care insurance, unemployment insurance, and most of all pension insurance while working in a foreign home office. And here's a big difference towards to the tax law, because unlike tax law, you are only ever subject to one social security law of one member state. That means you only pay your social security contributions in one country. As I told you before, from the tax law perspective, it can happen that you have to pay taxes in two different countries, and that's why there is this possibility of double taxation agreement. But you do not have this problem in the social security law within the EU. And the general rule is that you are always subject to the social security legislation of the member state where you actually work. That means where you actually physically work. And this general rule applies to both employees and freelancers. So to keep in mind, the place of your work determined the social security law which applies for you. And obviously, this is the problem, because if your employer is in Germany, but you are working permanently or just for some months because of Corona, for example, in Spain, according to this general rule, you would have to pay your social security contributions in Spain. But of course, as always in the law, there are some exemptions to handle this case, and I want to give you a short overview. What are these exemptions? And starting, first of all, with the employees. In a nutshell, the question regarding employees, which social security law is applicable to you, depends on the fact in which country do you actually live and work mainly. And according to EU law, there are two rules. The first rule is usually the social security law of your state of residence, where you carry out a substantial part of your activity, is the law applicable to you. And I assume that this sounds complicated, and I do agree. Just to clarify, what means a substantial part? That means more than 25% of your work must be carried out in the state of your place of residence. And this is in regards to working time or your wage. And to give you an example, if an employee lives in Germany and has there its place of residence and works at least 25% in Germany, German social security law applies even if the employee works up to 75% in another EU member state, in his foreign home office, for example, in Spain. But to clarify if the 25% are fulfilled, this determination depends on an overall assessment of all relevant facts of your individual situation. So I recommend to you, you should keep your place of residence in Germany. For example, your flat, your primary residence registration, your place of work according to your employment contract should be Germany, and all other indications which can prove that your place of residence is in Germany. So this is a really short and simple description of the applicable EU regulation. In details, these rules are quite complicated, and I can only recommend to you always to review your personal individual situation. But I can definitely say to you, if you plan to work for more than 1 year in your home office abroad, you should definitely clarify the situation with your employer and the authorities which social security law is applicable to you. This was the first exemption regarding employees. And now I want to come to the second exemption for employees, and this is the following. And unfortunately, it sounds a little bit more complicated. The social security law of the state of your employer's residence is the applicable law to you unless you carry out a substantial part of your activities in your state of residence. I want to give you also an example. Your place of residence is in Germany. You have a flat there. Your work activity in Germany is less than 25%, but your employer's residence is in Germany, but you work physically in Spain. In that case, also, German social security law would be applicable to you. So, and as you can see, these criteria, most of all, this place of residence, wherever it is, are very soft, very complicated, and above all, it is all a matter of interpretation. But this is good for you because if there is a matter of interpretation, you have a wide scope of action, and this is really good also for a lawyer, to be honest. That is why there is a possibility to receive a binding statement from the authority of the country of your place of residence. And in our use case, this would be Germany. That means in Germany, the responsible authority for this application is in German GKV Spitzenverband, and I'm really sorry I do not have a proper translation for this authority. But nevertheless, via this application, you will get a binding decision from the social security authorities, which social security law is applicable to you, and this is a really good thing to do. And furthermore, also good news for you is in case all the rules which I told you, the above mentioned rules, do not come to a sensible result for you and your employer, and you say that doesn't make any sense to me because, yeah, I'm working for a German firm, maybe for some weeks or months in Germany, but my base, my family members are in Spain, and later on I want to live in Spain permanently, then there's also a possibility to get an exemption from the authorities that the Social Security law of Spain in that case would be applicable to you. And this procedure is to avoid inflexible results. And I think this is really, really good that this procedure is possible. So as you can see, although it sounds a little bit complicated, you have quite a wide scope of action, and you should definitely use this. And then I have also some good news for you, because compared to tax law or other aspects in the Social Security law is the following. Even if the Social Security authorities later come to the conclusion that you and your employer have made an incorrect assessment of the applicable Social Security law, the authorities can make obviously a different decision. But, and this is the most important thing, this decision only applies for the future and not retroactively. Of course, this only applies if you did not intentionally choose the wrong Social Security law. But for example, in tax law, it's really a problem, because if the finance authorities come to the companies and check how did you declare your taxes and come to the conclusion, oh, you did a lot of wrong, and then you have to pay taxes maybe in another country. It's always not so easy for companies, because the decisions of finance authority are usually retroactively. But you do not have this problem regarding this question, and that is why I think this is also really, really good for employees and also for freelancers. But nevertheless, I would highly recommend to clarify this question in the beginning if you plan to work permanently cross-border. To sum up this first topic, if you have worked abroad in a home office during the last year because of Corona, from my point of view, the applicable Social Security law does not change to you according to the previous mentioned criteria, and also because, or by the way, there is an official statement of the German authority which says due to Corona, nothing changes. And that's why I think you can, if you're just in a home office at the moment because of Corona, you do not have to be worried so much. But if you intend to work abroad for a German firm permanently or for an extended period of time, I would highly recommend to clarify this in the beginning. This is so far regarding the employees. And now I want to come to the group of the freelancers. And the freelancers, I have really good news, because the EU law has a really good solution for freelancers, or in other words, self-employed persons. If you work as a freelancer in Germany, that means you are self-employed, and you carry out a similar self-employed activity in Spain, for example, you are still subject to German Social Security law if you do not work in Spain for more than 24 months. This is written in a EU regulation, and I think this is a really good solution. To be honest, you always have to check your individual situation, but as far as I understand this rule, it says very clear you can work for 2 years in another country as a freelancer. And after these 2 years, the previously described rules regarding employees also apply for freelancers, which means usually the Social Security law of your state of residence, where you carry out a substantial part of your activity, is the law applicable to you. And again, this is the so-called 25% rule. And if you are a freelancer, how to determine if the 25% rule is fulfilled? This rule relates to your turnover, your working time, your amount of services, also the place where the fixed and permanent establishment from which you carry out your activity is located, the usual nature or duration of the activities carried out, and in the end, also the will of the person concerned as indicated by all the circumstances. So again, you have a wide scope of action, and I think this is really good. And last hint regarding that matter, the Social Security authorities take into account the situation assumed for the following 12 calendar months. And this is why I would say, well, if you just for some weeks or months in another country, this is not such a big problem. Most of all, if you're an employee and not the employer. But you have to keep in mind, if you intend to more than 12 months, you should definitely clarify the situation with the Social Security authorities at the moment because of Corona. So to sum up this question, in which country do you have to pay your Social Security contributions? You should clarify as soon as possible which state shall be your state of residence. And as you can see, this is quite soft, to clarify which Social Security law of which country is applicable to you. This is it so far regarding these two important questions which you have to ask yourself. And now I want to come to the last further little hints, because there's, from my point of view, a very interesting question, or another very interesting topic is the question, what law is applicable in regards to your collaboration with your employer or your client if you work as a freelancer? And so far, the question of the applicable law was more relevant for companies in the B2B business. So for example, when I work as an in-house lawyer for a company, I always check if we collaborate with another company in another country, which law is applicable, under which law the contract is governed by. But meanwhile, because of digitization and the fact that every little child is able to offer its services worldwide, you also should ask the question, what law should my contract govern by? And I think this is a really interesting topic, and not so many employees or freelancers are aware of that fact. So I also want to differentiate between these two groups regarding employees. You should be aware of the fact that you as an employee have the right to choose the applicable employment law together with your employer. That means the applicable law is not mandatory by law. And this is why I would highly recommend to think about in advance, before you sign your employment contract with your future employer, which applicable law is favorable for you. I want to give you an example of what you should think about. Think about you work in Spain in your home office for a German firm in Germany, and you have any legal dispute and you want to file a legal action against your German employer. First of all, you should think about in which country could you get more and faster legal protection. And obviously, I do not have experience in Spanish employment law, but what I can say to you is that Germany has a very, very high standards of employee protection according to the law, which is why I would, in this use case, always recommend to choose German law, even if you work, for example, all the time in Spain, because you should think about, just in case your employment contract is under Spanish employment law, what would you have to do to file a legal action against your German employer in Spain? And I think this is really complicated and comes with a lot of legal costs from my perspective. And that is why, if you are good connected in Germany, for example, you have friends, you know, a lawyer or then you should think about, okay, I'm working permanently in Spain, but I have also people who can help me in Germany. You should choose German employment law, and according to the EU law, you have the right to choose, and that is why I really would recommend to you to use this right. Because if you do not make a decision under which law your employment contract is governed, then according to the EU law, your employment contract will be governed by the law of the country in which the employee habitually carries out his work in performance of the contract. And in our use case, this would be Spain. That means your employment contract would be governed by the law of Spain. So in case of any dispute, you should have to file a legal action against your German firm in Spain. And I think this is not so favorable for you. And another rule according to EU law is, if the applicable law cannot be determined, the contract shall be governed by the law of the country in which the establishment which engaged the employee is located. That means, in that case, Germany, because your German firm is based in Germany. And this can be helpful, but if the court, for example, if you work cross-border for 2 months in Spain, for 2 months in France, for 2 months wherever within the EU or outside of the EU, then a court would say, okay, I don't know where you actually work. So in case of doubt, the applicable law is Germany, because your employer is sitting in or has his residence in Germany. And that's why, to sum up this, from my perspective, really important question, please think about all the advantages and disadvantages, which applicable law would be most beneficial for you. As you can see, you also have a wide range of scope of action, and you should definitely use this. And now we come to the second group, the freelancers. It's also for freelancers pretty much the same rules. As a freelancer, you also have the right to choose the applicable law together with your client. That means the applicable law is not mandatory by law. And again, if you do not decide under which law your service contract is governed, then according to the EU law, your contract will be governed by the law of the country in which the freelancer has its habitual abode. And it's the same with employees. If you are in Spain, then your contract will be governed by Spanish law. This is it regarding this contract law issues. And I have one further hint which I want to give you regarding residence law. Because if you are an EU citizen, it is no problem to work from home abroad within the EU, because, as you know, as an EU citizen, you can work and live wherever you want within the EU. But if you are a citizen of a non-EU member state, please keep in mind that your residence permit in Germany will expire automatically if you leave Germany for more than 6 months. And I say this so, I would say this is so important, because I really make the experience that clients forget this, and they are outside of Germany for more than 6 months, and then they will come back and cannot, because their residence permit expire. And it's really important to know that this expiration happened by law. It's not a decision of the authority. And that's why please keep in mind, if you work from in home office abroad or across border, to come back within these 6 months. So this was a rough, short overview about the legal consequences, and I think a lot of information. And if you now have some questions, you are welcome to ask questions. And I think I give back to you, Logan. Thank you very much for your attention.
Wonderful.